Court calls the case. People versus Jalen Wynn.
Patricia Reiser on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Wynn. Ms. Wynn, can you unmute and state your name for the record?
Jalen Wynn.
Thank you. Your Honor, we are asking for an adjournment to review some more video, and there is pending bond violation reports as well.
Yes, I do see that. I will grant an adjournment. If you're viewing video, I'll adjourn this matter out to November 1st, 2023 at 9 a.m. As to the bond violation,
Your Honor, I did speak with Ms. Wynn regarding those violations. She will admit to missing those tests. I think her reasoning is twofold. She did state that because of her health issues, she is quite forgetful and sometimes does forget the test. She indicates that she doesn't get a notification. She just has to remember the test 3 times a day. And she also did inform me that she believes she may be testing wrong. Ms. Wynn, you may be able to help me out here, but she thinks that maybe when she tests, she's not waiting for it to go through before clicking accept. And then it's not registering her test as a full completed test. I will note she has no violations for testing positive for alcohol. She has been sober for about a year now. It's just her missing tests. I was hoping to just move her along, make sure that she gets back on track with those tests. But she is admitting to missing those today.
all right, here's what I'm going to do, because otherwise what's going to end up happening is I'm going to consider these at some point to be positive tests where she's missing this many. And so I think the safer bet at this juncture, so that we can make sure that it's happening, is I'm going to switch her to a scram tether. That way she won't.
I'm interviewing for, excuse me, my apologies for speaking out of turn. I am interviewing for jobs right now, and they are positions in upper administrative positions. I can't do that. I'm okay. I think that what happened is I'm not pushing the okay. It's just telling me that the test has been test has been sent, but then it flashes that it's been sent and it has the okay. I'm not hitting that okay. And I think that that's the problem. I'm taking the test religiously. I've been to AA, I've done all that.
Okay, ma'am, here's what I'll do. I was looking to try to protect you from having a positive test. I'll let you go. And if I have any more missed tests, then I don't have an option. It's either I'm going to incarcerate you or put you on the scram. If we're clear on that, then we'll do it this way.
I appreciate your making.
But I'm not going to, but if there are missed tests, I am not going to be hearing anything as to why. I need you to understand that.
I understand.
I'm just either going to put you on the scram or I'm sending you.
I understand.
All right. I'm going to indicate no more missed tests or potential jail. Okay. Thank you.
Thank you.
We'll see you on the 1st.
All right.
Good afternoon, Your Honor. This is Attorney General Michael Dovey for the people. Good afternoon, Your Honor. Douglas Gooch on behalf of the is present by right.
All right. I had the testimony, and this is a continuation of the preliminary examination. The testimony was heard in the case. I don't know that I took the people's motion to bind over. So I don't know if you have a motion.
Yes, Your Honor. Relying on the argument made the last time we were here, I do ask the court to bind over.
All right. Is there any additional argument for the court gives its decision?
No additional argument.
All right. In this case, and quite frankly, when one views the video, the factual circumstances are rather clear and somewhat straightforward. However, the defense raised 2 particular issues as it regarded the charges in this case. Specifically, one issue as to whether or not the use of the spray or the mace would constitute a dangerous weapon under the felonious assault statute is one issue. And then the other issue is whether there was say corrupt behavior in that regard, and that the misuse of office, quite frankly, or the offense itself can't be because of a policy violation. I'll clarify that more in a moment. As to the issue of whether or not the mace constitutes a dangerous weapon for the purposes of felonious assault, the court will answer that two ways. The court, first of all, believes that the manner in which it was used in this case, where the individual was handcuffed in the back of a police vehicle in effectively what is considered a cage where they cannot go, and that it was used, and that the individual, Cameron Hissong, frankly, at that moment, posed no threat whatsoever to the officer, that the manner in which it was used, this court does believe the people have sustained a burden of showing that it is a weapon. I would further note that when one looks at the jury instructions regarding felonious assault, that as to whether or not something would constitute a dangerous weapon also can become in the manner in which it's used, and what may be an ordinary, or at least an object that may not in and of itself be designed to be a dangerous weapon, that the totality of the circumstances and the facts and circumstances as to whether or not the people would be able to show that would have to be assessed by a fact finder as to whether or not its use constituted a dangerous weapon. So specifically in answer to that, this court does believe that people have shown that it's a dangerous weapon. However, even to the extent that the people did not, that question is not directly a legal question, but would be a question which would properly have to be determined by a fact finder as to whether or not, under the circumstances of this case, it was used as a dangerous weapon. So for those reasons, and all the other elements of that offense being shown, the court does believe that the people have sustained their burden as to count one and would bind the defendant over on that charge. As to the issue of the common law offenses, did commit an indictable offense at common law, namely the misconduct in office. The defense correctly points out, and I went through the cases that were given to the court, and I'm going to list them. They were provided in chambers conference, and the court reviewed them. What's clear is that the defendant did violate the policy, but the policy itself is not the basis, or cannot be the basis, for the misconduct in office. But certainly can be used as to whether or not there was corrupt intent in the commission of the offense. So in that respect, the court, and in viewing it that way, the misconduct in and of itself is not the basis for the charge, but can be, and this court does believe, could be determined by the fact finder as showing the corrupt nature of the defendant's action. And so for those reasons, the court does believe that the people also have sustained their burden and would bind the defendant over to stand trial on the offense of misconduct in office. Therefore, the defendant is bound over stand trial on both counts. All right.
Your just one item to make the record clear. The
Yes,
court had accepted those policies provisionally.
Yes.
Awaiting its ruling.
Correct. Yes, the court will accept those policies, and those exhibits are admitted. All right.
Thank you.
All right. And yes, we will, but we go through the arraignment, and so you You have been presented the information in this case and waive its reading at this time, sir.
Yeah, we'll wait for it.
All right, defendant having waived for reading standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
May 22nd at 1:30 before Judge Slay.
May 22nd, 2025, 1:30 before Judge Slay. Bond in this case will continue.
Thank you.
All right?
May I approach the side information?
Yes. Sir.